physics and management consulting. And you do
Good afternoon.
being on sabbatical, I get an opportunity to go to all sorts of places.
Thank you so much for coming.
We have so much in the Bay Area, but I don't have much time. Okay, here we go.
Thank you so much for coming. I'm sorry, we don't have a microphone today, so I'll ask Carter to speak loudly, and I will try to do so as well. Thank you. When I was with the students planning this event a little while ago, we were cautioned not to have an event on a football Friday. And we actually said, I said, no, we should have an event on a football Friday, right? This is football at Notre Dame is important, and it's when the whole community gathers. And when the whole community gathers, we should gather to talk about some of the most important subjects facing the university. And I thought we could actually get more people on a football Friday. And I'm absolutely thrilled that you all came. So thank you for coming and helping to make this a success. Thank you very much. A few announcements and a few more thank yous. First of all, there are several members of the Office of Undergraduate Studies here, the Dean's Office. Ava Preacher, Dean Stanfeld, Vicki, I think I saw. They are making this possible. So thank you very much for your support. And they're also buying you lunch, so you should thank them as well. We have Dean Kilpatrick here. Thank you for coming. We have several faculty. Thank you especially to the faculty coming. One of the reasons for Professors for Lunch was to have a forum for students and faculty to dine together, to talk together. I don't think we do that enough here at Notre Dame. And so thank you especially for the faculty for making this part of your day. We're very happy you're here. And three students I want to thank in particular. Megan, where's Megan? Organizing the team. Megan right here. Neil Ravinda. Thank you, Neil. And then let me please introduce Lizzie Helpling, who's going to introduce our speaker. One other announcement. We have another event on this subject on 2 weeks from today, the Friday before the Michigan game. A faculty panel titled Why Notre Dame is Suing the Obama Administration and Should It Be Doing So. 4 faculty members from across the university. We'll hope you come back for that event. Today's event, we asked Carter to give a briefing, some background information, and also to provide his own view of the subject matter. But this is just the beginning of our conversation, so we hope you'll come back again on the 21st. I know some of you are going to have to leave. You'll have other obligations. Carter will go for about a half an hour or so. If you have to leave after that, perfectly understandable. When you do so, if you could bring your trays back and just dispose of them as you normally would, that will help the dining hall staff quite a bit. We don't want to ask them to clean up after us. So just please excuse yourself if you need to go early and bring your trash with you. Lizzie.
Carter Snead is the William P. and Hazel B. White Director of the Center for Ethics and Culture and a professor of law. His principal area of research is public bioethics, the governance of science, medicine, and biotechnology in the name of ethical goods. His scholarly works have explored issues relating to neuroethics, enhancement, stem cell research, abortion, and end-of-life decision-making. Please join me in giving a warm welcome to Carter Snead.
Thank you all very much, and I'd like to echo Phil's thanks to all of you for coming. I see some friends, some old friends from the faculty, some new friends from the faculty, students. Thanks, Ava, and your group for putting this together, and everyone who worked to make it happen. The lights just dim, or am I having a stroke? So there will be a PowerPoint presentation that accompanies my remarks. When Phil originally asked me to appear at the Professors for Lunch event, I thought I was going to be talking about the moral and human significance of the taboo of cannibalism. But turns out that's not what this is. Obviously, I'm here to talk about the Affordable Care Act, one aspect of the Affordable Care Act, the contraceptive and other preventative services mandate particularly how it affects concerns relating to religious liberty and conscience. And obviously this is a very contentious issue. There are a lot of people of goodwill who have different views on this matter, especially here at Notre Dame, where we are in some ways centrally involved in the public conflict. And so my aim today is sort of twofold. One is to try to give a descriptive account of the issue itself, starting back at the inception of the provisions in question involving the preventative services mandate, and then also to describe the sort of the subsequent events that unfolded after that was announced, including Notre Dame's role, and then to sketch out. So that's a descriptive aspiration that I have for the talk, and then there's a more of a prescriptive or normative dimension of the talk, where I will share with you my own judgments about this issue and express some concerns that I have that you may or may not share, but we can have a good and interesting and hopefully spirited conversation after I conclude my set piece here. This PowerPoint presentation was actually originally prepared for a different audience, for an audience of physicians at the University of Chicago, but it will serve our purposes here. And I'll move through it somewhat quickly so I can get to questions and discussion, because I think that'll be more interesting for everyone in any event. But let's start with the timeline. We can trace back this discussion, this issue, to the passage of the Affordable Care Act itself, landmark legislation, which is a very large piece of legislation, 2,500 pages, that does a whole array of things. And I'm only going to be speaking about one very narrow aspect of the Affordable Care Act. My remarks are not meant as a criticism or an endorsement of the Affordable Care Act in its entirety. There are aspects of it that I think are wonderful. There are other aspects that I think might prove problematic. That's not what the talk is about. The talk is about this one narrow feature. In the Affordable Care Act itself, there is a requirement in the statute itself that group health plans must cover some preventative services without cost sharing. Now that's a term of art. That means co-payments, co-insurance, deductibles, and the like. Essentially out-of-pocket expenses on the part of the employees who are covered by these group health plans. So there's an overarching umbrella category of preventative services that have to be covered without cost sharing. But the statute itself, the Affordable Care Act itself, did not specify which services, which medical interventions, which kinds of pharmacological interventions, which drugs, prescriptions, and the like, were deemed preventative services for the purposes of this mandate. Instead, what it did is it delegated, this is fairly typical, it delegated the responsibility to various administrative agencies, which are, of course, housed in the executive branch of our federal government. That is, the President of the United States is the head of the executive branch, underneath which are these administrative agencies, whose job it is to flesh out the details, sort of unanswered questions about statutory requirements. And in this case, the statute delegated the responsibility to the Department of Health and Human Services and others, Department of Treasury, the Labor Department, departments that oversee these group health plans, to flesh out the details regarding precisely what form of preventative care would be subject to this mandate. So, on July 2010, in the wake of the passage of the Affordable Care Act, the three administrative agencies, Health and Human Services, Treasury, and Labor, issued regulations specifying, really announcing that 1 year from that date, those agencies would announce which services counted as the preventative services that had to be covered without cost sharing. And they further specified that an agency that was at that time being created, a sub-agency of the Department of Health and Human Services, called the Health Resources and Services Administration, would do the work of identifying which services count as preventative services for purposes of this mandate. Now, HRSA, the sub-agency of HHS, in turn delegated the responsibility to analyze this question of what should qualify as a preventative service for the mandate to a non-governmental body, a very esteemed professional society called the Institute of Medicine. And they convened a subcommittee to deal with that question. Fast forward 1 year to August 1st, 2011. This is probably the first that Notre Dame got into the news, and the first real serious sustained attention was given to this issue in the media, HRSA came out with guidelines specifying which services would be covered. And in July of that same year, the Institute of Medicine made a recommendation about what should be covered, which HRSA adopted in its entirety. And the bottom line is that preventative services, which carry with it the mandate for coverage without cost sharing, includes all Food and Drug Administration approved contraceptive methods, sterilization procedures, and patient education and counseling for all women of reproductive capacity. So this, now just a little bit of background, Congress itself had tried over many, many years to pass precisely this kind of mandate, precisely this kind of a rule that would have required employers and health plans to cover precisely this. On 21 different occasions, the House of Representatives, the Senate tried to take up legislation to do precisely this, and was never able to get a sufficient majority to do so. On each occasion, the effort failed. So it's quite notable that through administrative regulation, the executive branch was able to achieve what Congress had failed to do over a period of time. Now, there's a very technical detail about grandfathered health plans that are not subject to this mandate. We don't really need to concern ourselves with that. What that has to do with is certain kinds of health plans that had locked in their benefit structure before the Affordable Care Act was announced and would not make any material changes to that benefit structure. Most institutions, if you make any routine changes, or even non-routine, certainly non-routine changes to your benefit structure, you lose your grandfather status. Notre Dame is not grandfathered in. Most employers are not grandfathered in, and the Health and Human Services Department has speculated that over time the class of grandfathered employers will shrink to almost nothing. But there are a number of different kinds of waivers that have been granted, not just from this contraceptive mandate, which I'll get to momentarily, but there are waivers from the entirety of the Affordable Health Care Act, which have been granted more or less on an ad hoc basis by the Secretary of Health and Human Services. That's been the matter of some controversy, concerns raised about exempting different businesses from the Affordable Care Act's strictures. I won't get into that, but that's worth flagging. And I'll also add that there are religious liberty exemptions to the entirety of the Affordable Care Act that are in the statute itself that speak to those kinds of religious traditions, the Amish and others, who are, as a matter of their faith tradition, opposed to participating in insurance frameworks like this. Certain Native Americans are also excluded as well. So, two objections were immediately raised to the mandate. One I will refer to as the pro-life concern. That's how those who raise these concerns would identify it. And the religious liberty, and the second sort of species of concerns are religious liberty concerns. My remarks today and the lawsuits that are unfolding in Notre Dame's participating mostly relate to the second concern. So I'll pass very quickly over the first concern. I'll say something about it. In summary, the pro-life concern is that certain of the approved drugs, and the one in particular that is singled out is ulipristal, that is LO1, sometimes referred to as the 5-day after pill, can, in some circumstances, at least according to the FDA labeling, kill the developing human embryo either just before or just after implantation in the womb. Now, the word abortifacient has been a matter of some controversy. Abortion is technically described, at least in the medical literature and the conventional wisdom among those experts who deal in these matters, as being the termination of the life of an embryonic or fetal human organism post-implantation, after it's embedded itself in the uterine lining of its mother. The LO1 drug, according to FDA labeling, does that in certain animal models. I can get it by suppressing progesterone. And so if you look at the FDA labeling itself, it talks about the progesterone repressing effect of LO1 actually results in alterations in endometrium that can affect implantation and also and thus contribute to the efficacy of the drug itself. And so there are three ways that LO1 has an embryocidal property and two of them are post-implantation, and that's why the FDA has actually indicated in its labeling that LO1 is contraindicated for pregnancy because in the animal models and the experimentation that they've done, the use of LO1 has resulted in the termination of pregnancy. It can also prevent implantation itself, which is a matter of grave concern to those who recognize the sort of the continuity of development, the equal moral status of all human organisms from conception to natural death, which of course is the institutional position of Notre Dame, that of the Catholic Church. We don't need to talk about the more technical details of how that works. If you'd like to take that up during the question period, I'd be happy to discuss it. On August 3rd, 2 days later, HHS, Treasury, and Labor issued an interim rule, a final interim rule, which is a legally binding, effective pronouncement. That is, it has the same force as the statute itself. The Affordable Care Act is a law. It binds us, obviously, as citizens, as certainly it binds those who run these group health plans. The final interim rule has the exact same legal effect. It's a law. The violation of the law results and triggers very significant penalties, Treasury regulations, onerous and fines that are meant to essentially bring the violator to a halt immediately. We can talk about those a little bit if you want to later. But this is a law. Once it's announced as a final interim rule, it's not provisional, it's not conditional, it's not a promise to do something. It is in fact a rule that has concrete legal effect. And this final interim rule included what was styled by the administration as a religious accommodation. Meant to, in their words, respect the unique relationship between the house of worship and employees in ministerial positions. So it's singled out, again, that's a term of art that we'll hear more about next week. It's called the ministerial exception. Most legal scholars, most courts, all courts, now the Supreme Court has just passed on this issue, recognize that certain religious entities do have exemptions from some otherwise generally applicable laws as applied to those who serve in ministerial positions. It's called the ministerial exception. It was recently affirmed in a 9-0 vote in a case called Hosanna Tabor involving a Lutheran elementary school, I think, and a teacher there who was bringing a discrimination claim against the employer. She lost in the process of affirming the lower court's judgment. The Supreme Court recognized this ministerial exception. Ministerial exception is a narrower classification of exemption because it only applies to those who serve in ministerial roles than would a broader notion of religious liberty as applied to institutions to conduct their affairs. So if you look into the religious employer exemption itself that was announced in the final interim rule, it turns out that language, the ministerial exception language, was maps onto the scope and substance of the rule itself because it's quite narrow. That is, there's a religious employer exemption for certain kinds of religious employers who can satisfy all, not one, but all of the following criteria. One, for an employer to be exempt from this preventative services mandate, the employer has to show that the inculcation of religious values is the purpose of the employer itself. Now, the word purpose is a little bit ambiguous. It's not clear if it means its only purpose, if it's primary purpose. As interpreted by certain courts, these have been interpreted fairly narrowly. So it has to be the sort of central purpose of the institution itself. Second, the institution has to primarily, again, the word primarily is not defined, and that's, I think, problematic, but it says primarily employ persons who share its religious tenets. It also has to primarily serve persons who share its religious tenets. And fourth, and this is the most strict of all four of the requirements, all of which are required, it has to be organized according to certain provisions of the Internal Revenue Code that are exclusively defined churches, integrated auxiliaries, conventions or associations of churches, as well as to exclusively religious activities of any religious order. So these two provisions of the Internal Revenue Code, even if the first three are in some ways ambiguous, and as a lawyer, I would try to argue if I were representing Notre Dame that we might meet those criteria. I think I probably wouldn't be successful. But the fourth clearly excludes us as a formal matter, because we are ineligible to file as an entity under those provisions of the code because we are not a church, we are not an auxiliary of a church, we are not a convention or association of churches. And you'll notice it applies to religious orders insofar as it speaks to the question of exclusive religious activities. So secular employees of a religious order would not be covered, and in all likelihood by this exemption. So it's a very, very narrow exemption. Obviously, by virtue of the fact that it's on the federal scale, there's never been an exemption as narrow as this. There's never been a rule as sweeping as this with respect to bringing all sorts of religious entities under its ambit. And there are 3 states that have passed comparably narrow laws. Only 3 states, and in those cases, states can avoid. Entities in those states can avoid compliance by either dropping their health program altogether, which you can't do under the Affordable Care Act, by dropping prescription drug coverage, which you can't do under the Affordable Care Act, or by simply opting out altogether and taking the consequences, which are not as onerous as the Treasury regulations under the Affordable Care Act. So, as I said, only 3 states have comparably narrow provisions, and thus most Catholic institutions, just by way of example, there are other institutions as well, universities, hospitals, social service agencies are not covered by the exemption. Notre Dame is not covered, and thus we are all compelled to abide by the mandate itself. Also excluded from the exemption are entities objecting on non-religious moral grounds. So if you have an entity that has a kind of normative set of commitments that animate that enterprise, one of which might contradict or might prevent its participation in this kind of a mandate, those are not covered by the religious exemption. Non-denominational entities, this is a very big issue for a lot of Protestant groups, are not covered, and individuals with religious or moral objections are not covered. So individual small business owners who, for example, want to run their business in a way that reflects and is integrated with their most deeply held religious principles are also not included under this exemption. So there was, interestingly, a reaction to this announcement and also to the narrowness that was surprisingly bipartisan, especially among Catholics. So we actually had a situation where Catholics across the ideological spectrum, left, right, and center, at least at the outset, came together in agreement that the exemption offered, the mandate, the scope of the mandate was too broad, too onerous, and should be dialed back. And I think, and so in response, I think, to that sort of bipartisan reaction, on January 20th, 2012, the HHS was forced to respond, and they responded in a way, they didn't respond substantively in any different way. They said the rule is going to stand unchanged, but they did offer a 1-year safe harbor period for non-exempt organizations to comply. So, and you may remember in reading in the press, Cardinal Dolan and President Obama had a series of exchanges and meetings before January 20, 2012, in which at least Cardinal Dolan thought that that there would be an accommodation that would be satisfactory to at least Catholic institutional interests, and especially among those who had raised concerns. And when this came out, Cardinal Dolan was disappointed and famously sort of asked President Obama, does this mean that we can continue the discussion to try to find some mutually satisfactory accommodation? And he was told, no, this is simply a year to find a way to organize the affairs of these institutions to comply with the mandate. So the criticism intensified, you may recall. And again, the left-center-right coalition held, which is very unusual in American politics. I mean, Catholics generally are not, I mean, they look like America. There are a lot of, they disagree about a lot of things, and there's a left, a center, and a right, it's unusual when they come together in a bipartisan coalition. That coalition seemed to hold. The U.S. bishops issued letters to be read at Mass across the country, and there was another response that came from HHS in February 2012. President Obama himself gave a speech in which he said the final rule will remain unchanged, but promised to try to find an accommodation whereby the employer, and this is a quote, will not have to pay for the objectionable services. And without elaborating, specifically said, we're going to, the idea is we'll try to find a way to require insurers to notify plan members of their entitlement to these services by virtue of their memberships in the plan, by the way, without involving without requiring the plan itself to pay for it or to communicate. Final rule was issued on February 15, 2012. Now, interestingly, there's some confusion about this. The accommodation that I just described to you, that was kind of promised, may not be the right word, sort of discussed by the President and the Department of Health and Human Services, to say we'll try to find some accommodation. In the final rule itself, it was unchanged. Okay, the rule was unchanged. That is, the exemption itself was preserved in its original narrowness. The sweeping mandate was exactly the same as it was. There was a 1-year safe harbor provision for non-exempt institutions. That is just basically a deferral of 1 year until the Treasury regs were assessed for non-compliant entities. And then in the rule itself, there was a kind of announcement of a plan to initiate a rulemaking in the future, which in principle would require issuers to offer insurance without contraception coverage to an employer, and also simultaneously offer contraception coverage directly to the employer's plan participants and other beneficiaries who desire it with no cost sharing. So the idea would be, again, it's an idea, it's not a formalized rule. The idea is we will find a way to compel insurers to cover the contraceptives, abortifacient, drugs, and sterilization without requiring you, the employer, him or herself, to pay for it. Although there was no opt-out provision. There was no opt-out provision for employees. So, for example, here at Notre Dame, and it's also not clear how the communication process would work without involving the host institution itself. And then, moreover, it's not clear at all how you prevent the insurance company from building the cost of the free contraceptive and other drugs into the price of the plan itself and passing it along directly to the employer. Now, you can say that you try to prevent that or say that they shouldn't do that, but you really need forensic accountants to try to enforce something like that on a massive scale. And it seems unlikely to me that would be the plan if there is a plan that finally comes forward. It's not clear. This is a kind of resolution to find a plan, but not a plan itself. But one major omission here in the February 15th final rule is regards self-insured plans. Self-insured plans are those kinds of plans where there's not an insurance company that provides, and a lot of big organizations do this. Notre Dame does this for its faculty and staff, for example, where there's no insurance company that provides the plan. What happens is Notre Dame itself pays for the coverage, and there's a third-party administrator, Meritain in our case, who takes care of the administrative side. But they're not. But it's really only one institution that is providing the funding and the coverage for the insurance plans themselves. Now, for our students, we actually do coordinate with an insurance company called Aetna, and so the model that was described before, at least on its face, is plausible. For self-insured plans, it's hard to see how you could get that sort of bifurcation that was discussed before. And I'll say also that. But they did say, we'll try to find a comparable arrangement. They said, we'll try, if this plan goes forward, we'll try to find a comparable arrangement. So on March 16, 2012, there's another document was issued called an Advanced Notice of Proposed Rulemaking. The Advanced Notice of Proposed Rulemaking is simply a kind of, really, it's a kind of announcement that we're considering regulating in this particular area, and it's kind of almost a brainstorming document. If you read it, basically it says, here, we have some draft ideas about how to implement the February 10 policy that I was just discussing. There are a variety of mechanisms to offer contraception, et cetera, to plan members. Call for comments, 90-day comments, and they said, we'll finalize the rule if we can identify a rule by August 1, 2013, which is the end of the temporary enforcement safe harbor time period. Okay? So the Advanced Notice of Proposed Rulemaking threw out some possibilities. Said, well, maybe we could structure things in a way to allow to compel insurance companies to pay and leave the payment side of the equation simply to them and avoid compelling payment on the part of these institutions themselves. And they talked about, for self-insured entities like Notre Dame, maybe we can conscript the third-party administrator into paying for these services without compelling the entity to pay. But all these are just kind of ideas. They invited submissions and opened comments for a 90-day period. During that time, by the way, the third-party administrator sort of professional association submitted comments saying that there's no model, there's no structural model that would work to bifurcate the payment system for these drugs and these services in the way that is contemplated for insurance companies. So it's not possible given how they do business and what their incentives are and what they're in a position to take care of. So for self-insured entities, I think the problem is still very significant. And for those, but the most important thing for us to take on board here, is in terms of understanding what's happening, is this has no legal significance, March 16, 2012, other than to simply say that we're in the process of considering how we might issue additional regulations to address the concerns that have been raised, and we'll do so August 1, 2013. Now, for most of the people engaged in this dispute, that was an unsatisfactory kind of a response because, for one thing, it's just sort of a vague promise to find a resolution that would be acceptable. And then the timeline is August 1, 2013. In the meantime, these entities have to figure out ways, their benefits and compensation structures, to plan. It's a fairly front-loaded process. But on top of that, there's a political concern that August 1, 2013 is significantly after the presidential election, which means that the optimal time to influence either of the campaigns, and certainly the optimal time to influence the incumbent government, is before the election in its first term. And I think that just stands to reason. And there was a concern that this was just simply moving the process forward, so it would be eliminated as a kind of question that would be debated throughout the election season. So, in the wake, well, let me back up a second. In the wake of this, obviously there were lawsuits filed, including by Notre Dame. And you'll hear more about this next week, but the lawsuits seek relief under two theories. The first theory is by virtue of a federal statute called the Religious Freedom Restoration Act, which was enacted in the early 1990s, overwhelmingly approved on a bipartisan basis, signed into law by President Clinton. Senator Schumer from New York was one of the co-sponsors of the bill. And what the law says is whenever the federal government impinges upon, substantially burdens the religious liberty of an individual or an institution, it will only be permitted to do so, the government will only be permitted to do so, so long as it can identify a compelling justification, the most compelling justification, the most compelling kind of justification that the government can invoke in such a situation. And then secondly, and this is the most important part, the means selected to pursue that compelling interest have to be the most narrowly tailored means available, the least restrictive means available. The means have to be calculated to have the least amount of impact on religious liberty of the affected parties. And only if both of those things are satisfied will the state action be sustained. Otherwise, the law will be struck down. And that's actually what happened recently in the case in Colorado. There was a case involving a small business in which the district court judge, that is the federal trial court judge, found that the government's, even if we assume the government's interest here is compelling, that is, the government's interest would be to maximize access to these kinds of drugs and services, and not merely to maximize access to these kinds of drugs and services, but the import is to try to make sure that religiously affiliated institutions who have objections to these kinds of services and drugs, to maximize access among those institutions, among the employees of those institutions. And then secondly, that the means chosen would be the least restrictive possible. And so what the court found was, and I think this is we probably need to see more of this, what the court found was, even if we grant that there's a compelling interest in maximizing access on the part of employees to these kinds of drugs and services, this means that has been chosen here, this mechanism of doing so by requiring the institution to facilitate the provision of these drugs, that is using the employer plan itself as a mechanism to transfer these entitlements, is not the least restrictive means. There are other ways that this could be accomplished. For example, we already fund $1 billion a year of family planning involving contraception and sterilization through Title X, which is a federal program that subsidizes clinics and organizations that provide these services and these drugs at a greatly discounted rate. there could be a direct tax credit, for example. The exchanges that the Affordable Care Act sets up to provide health care to those people who opt for that subsidized, for a premium subsidy program that the Affordable Care Act creates, those would all be less restrictive ways of getting these people access to the drugs. This is, however, a more onerous way to do it by conscripting the institution itself in doing so. And that was the ground that the court found and struck down the law as applied in that jurisdiction to that party. The second ground for opposing this mandate in court is under the First Amendment itself, and it's a very complicated area of jurisprudence. You'll hear a lot about it next week. There is a general default rule that a neutral law of general applicability is not going to be overturned in the face of religious liberty concerns, but for the most onerous or compelling reasons. The question of whether or not this law is a neutral rule of general applicability, I think, is a hard question, and I think there's a good case to be made that it's not a neutral law of general applicability because it has a religious exemption already in it. It has exemptions, many different kinds of exemptions, not just to this, but to the law more generally, and so it's not neutral. It is. There are certain kinds of religious employers that qualify for exemptions, and certain ones that don't. And under the prevailing jurisprudence of the First Amendment, I think there's a good argument to be made that this also violates the First Amendment. But it seems to me very clear that there's a strong case to be made that it violates the Religious Freedom Restoration. So let's just turn away from the technical legal details for a moment and talk about very briefly reasons for serious concern. I've already mentioned the concerns regarding the drugs that can, in certain cases, function as abortifacients. Again, that's ulipristal, the 5-day after pill. Secondly, I think that it's simply true that this is an unprecedented, at least imposition. Violation is a normatively charged word. I would use the word violation here, of religious liberty and conscience. The form of governance that brought about this outcome, I think, is flawed, both in terms of its lack of transparency, delegation through a whole chain of unaccountable institutions, including the non-governmental agency. I think that the social engineering piece of the puzzle here, by the way, is gravely flawed because the agencies that considered and that created this rule, that laid the architecture of this rule, didn't even consider alternative ways of doing it. Didn't even consider alternative ways of providing access to contraception and sterilization without, again, conscripting these institutions into the process. I'll talk momentarily about coercion, and then finally, the thing that is a major concern for me, and I think for others, is that this is what this threatens to do. And Cardinal George of Chicago has said what this is doing essentially is making it more difficult for private entities, private associations and institutions who serve others in important ways, social services, hospitals, caring for the poor and the like. It makes it harder for them to do to pursue their vocations in an integrated way. That is, in a way that reflects their deepest normative commitments and allows them to bear witness to the truths of the principles that they affirm. And I think over time, the worry is that this has the potential to crowd out from the public square these mediating institutions that are not governmental institutions, that are in fact, again, voluntary associations, people coming together because they want to serve others. I worry that making them more difficult is going to lead to a less rich situation. Now, I'm almost out of time, so let me. I've already talked about how the religious liberty is a unique good here. Is not simply the freedom to worship or freedom to pray or freedom sort of internal activity, but also it is a kind of freedom to live, act, and organize your affairs in voluntary associations with integrity. And there are a whole lot of salutary examples of this kind of faith in action: charities, social services, hospitals, schools, and universities, including our own. And as Cardinal Keeler of Baltimore said, there are a lot of mission-oriented faiths, ours, the Catholic Church being one of them, which provide these services not because the people that we're serving are Catholic, but because we are Catholic. That's why we care for the poor. That's why we try to feed the hungry, clothe the naked, and heal the sick. And yet, this religious exemption reflects a very limited, and I would argue, cramped conception of religious practice. That is, it reduces religious practice to private belief. It's only inward-looking private entities that are deemed sufficiently religious to merit the exemption. There's no space for faith in action. directed towards others without regard to their beliefs, and it contemplates 2 tiers of religious institutions, which I think is unprecedented and also problematic. I've already talked about why I think the accommodation is insufficient. We talked about self-insured plans. We talked about the levels of delegation that have happened and the sort of governance by vague promises. That is, here's a safe harbor provision. We promise to find an accommodation. A legally non-binding promise is not a way to govern, especially in areas that are as vexed and contentious as this. The Institute of Medicine did not engage in any empirical work at all involving the costs or benefits of this program. In fact, when asked, the director of the committee, Linda Rosenstock, as the dean of UCLA Public Health, said, when she was asked directly, how did you factor in religious freedom, religious liberty into this calculus? Her response was, we did not consider individual personal feelings, which I think is an impoverished and reductive understanding of religious freedom and conscience. So we should probably save time for questions here. We have a few minutes remaining. Again, like I said, this is a complex question. A lot of people with goodwill disagree with one another. There's a lot of moving parts, but let's open the floor for questions and discussion, and hopefully we can learn from each other. So thank you very much.
A couple matters for question and answer. Again, if you need to leave, please excuse yourself and bring your trays and rubbish. If you have questions, let's keep them short. There's a lot of people here and a lot of people I'm sure who want to talk, so make sure your questions are indeed questions and they're short. And we have a tradition at the Tocqueville program, we always start with students. So if there's any undergraduate students who would like to start the question period. Please.
Could you explain, I guess, what the future holds with the suit the university brought against the government? What's kind of the chain of courts it would go through, or how?
Yeah, that's a great question. So, in the federal system, you start with your complaint at the trial level, the federal trial level, which is what we've done. The Northern District of Indiana is where we have filed our suit. Our suit was filed in conjunction with I think many other litigants in many other jurisdictions. The way it works procedurally is we file a complaint to try to enjoin the effect of the rule as it's been enacted. The court then, in the first procedural way to do that, through seeking an injunction, trying to enjoin. That's what happened in Colorado. The court enjoined the effect of the law on the complaining party, the private business, in that particular case. So, what has happened is the government's first response is more procedural. They say, well, this is an unripe claim, or you don't have standing to claim it. We do have standing because we're affected by it. Ripeness is a term of art that relates to whether or not the fact that the case or controversy is ready to be resolved. Have the events that are being complained of happened yet? Is there actual injury at the moment that the person can meaningfully complain of, or is this a premature kind of a lawsuit? And our argument, and the government would say, this is premature, you're in the safe harbor provision, you have until August 1, 2013, until the Treasury regs are imposed on you for failing to comply. And our response to that, there's actually an affidavit by John Affleck Graves that was filed along with our motion that explains why it is that in this very moment we're harmed by both the uncertainty, and secondly, the benefits and compensation process is a very front-loaded process. So right now, we're having to figure out what our insurance coverage, what the shape of it's going to look like, how to budget for it. We have limited resources, both for the faculty and staff, which are insured through a self-insurance structure, and for the students who are insured through an actual insurance company, namely Aetna. So what will happen is there'll be an injunction. The court will, if I'm a judge, I'll just be totally pragmatic. If I'm a judge and I know I'm 60 days from an election that might settle this entire matter, I'm not going to exert a lot in terms of judicial resources triage. I'm not going to marshal all of my judicial resources to deal with this question immediately. I'm going to probably try to delay the hearings and my disposition of those motions until after the election, because that, in some ways, will be dispositive of the issue itself. And so, if I were a judge, that's what I would do. Some judges, this judge in Colorado, dealt with it immediately and joined the law. Right now, they're still in the midst of filing their motions and responses. They haven't argued the motions yet here in the Northern District of Indiana. If that happens, Then there'll be an appeal to the intermediate appellate court between the trial level and the U.S. Supreme Court, which is, in our case, the U.S. Court of Appeals for the Seventh Circuit, which sits in Chicago, which covers this sort of geographic region. And then if the losing party in that case has the opportunity to appeal to the Supreme Court, which has the discretion in this case to take the case or not. So that's what the shape of the roadmap of the litigation will be going forward.
Since we don't have a microphone, maybe if you could stand and also tell us who you are and how you're affiliated here at the university. Any other undergraduates? Please. Tell us who you are.
My name is Zach Harris. I'm an undergrad aerospace engineering student. A concern that I've heard raised is if the government grants a exemption to, say, Notre Dame or like Catholic organizations because they're religious institutions, how does the concern that is that the government would start granting exemptions to large religions per se, but not to small ones because they aren't a religion.
Yeah, it's a line drawing problem, right? And you could say, well, what if the way I think the law deals with that concern is through the mechanism of the Religious Freedom Restoration Act itself. Okay, so the Religious Freedom Restoration Act was a response on the part of Congress to the Supreme Court. The Supreme Court said, here are the boundaries of the First Amendment. Okay, there are some claims that you can bring as a First Amendment claim, some that you can't. But we believe that religious liberty is an important good, and so we invite Congress to create permissive regimes of accommodation for those institutions that require it, that are not may not be required by the First Amendment itself. So the First Amendment is a kind of a floor on the religious liberty. It's obviously not the ceiling. And so there's an invitation to the political branches to find ways to accommodate religious liberty when the state can do it, right? So if you look at the structure of the Religious Freedom Restoration Act, it actually, I think, does that in a pretty decent way. It says the state cannot substantially burden the religious liberty of an individual, doesn't have to be a part of a big church or a little church or whatever, or an institution, without the most compelling reason and without using the means that are most narrowly tailored to that end. And so, for example, I would say, so that contemplates religious liberty is not an absolute trump card against any state action, right? I mean, there are all kinds of reasons compelling reasons why we want to limit the religious liberty of certain kinds of individuals or institutions. And so, but what the Religious Freedom Restoration Act does is it puts the government to the burden of saying, we have a very compelling reason here to want to limit religious liberty. And the way that we've chosen to do it is the narrowest, least intrusive means available. So it invites the government and the court to sort of evaluate the balancing that the government has done with respect to allowing religious liberty while pursuing important good that the state has to pursue to provide for the common good. Okay? So to apply to this case, I would say, look, we can argue about whether or not access to contraceptives and sterilization and certain drugs that can cause abortions are goods or not, right? We can argue about whether or not that's a compelling reason. I would say even if you stipulate that it's a compelling justification, the way that it was done in this case is not the most narrowly tailored way. I can think of 5 ways to maximize access to contraception and sterilization that doesn't involve at all the compelled facilitation by individuals or institutions. And that, to me, that mechanism, that structure that's embedded in the statute itself, I think, is a way of balancing the good of religious liberty with, obviously, other goods that sometimes have to override religious liberty.
My name is Michael Aspen. I'm a senior econ and poli-sci major. I was just wondering if the lawsuit's not successful and no exemptions granted, what path forward does the university have?
That's a great question. So there are, the fines are very, very onerous. Basically be about $10 million a year for Notre Dame if we didn't, the fines are twofold. It's something like $2,000 a day for each day of violation of the rule per employee. Or no, I've got that wrong. The sum ultimately would be like $9 million. I just read the affidavit this morning. $9 million per year is basically what Notre Dame is looking at in fines, treasury fines, if we don't comply with this. And so the question would be, what do you do? And let me underscore something here. There's some dispute, and I'm not a moral theologian, there's some dispute about complicity and cooperation and can we participate in this kind of regime in a way that preserves our, which doesn't make us culpable in some way in the provision of these. And I frankly don't know the answer to that question. It may be the case that we could somehow facilitate access to these things in a way that under traditional principles of complicity comport with the tradition. But I would say that to focus, and those are important questions, but they're not the first order question. The question of what we can live with is not the same thing as what the government is allowed to impose on us, right? That is, the government could ban Mass being celebrated on a Wednesday, assume not a holy day of obligation, right? And we could live with that, right? We could live with that. We could organize our lives in a way with integrity that wouldn't conflict. But the truth is, it would still be a violation of religious liberty for the government to do it. It would be an actionable violation of religious liberty, and it would be worth, in my judgment, suing the government to stop them from doing that. Yes, sir.
David Anderson, senior accounting and economics major. With the election coming up, there's significant political uncertainty surrounding this issue. If Mr. Romney gets elected president, do you think that there'll be a different way that the cabinet, specifically the Health and Human Services Department, approaches this problem with the safe harbor period ending in August?
Yeah, I mean, well, yeah, the question was, how would a change in administration, tell me if I'm getting your question right, how would a change in administration affect this issue? Is that what you're asking?
Yeah.
How would, if Romney gets elected president, what's going to happen to this question, right? Well, he's said explicitly that, and again, this is an administrative level, an executive level rule. It has the force of law, but it's done entirely by administrative regulation, which means it could be repealed by administrative regulation. So he would have the authority, even putting aside the question of the wisdom of the Affordable Care Act more broadly. You don't have to undo the Affordable Care Act to undo this. What you have to do is have Secretary of Health and Human Services, Secretary of Labor, Secretary of Treasury, who would take the steps to roll back this regulatory provision, and of course they would do that. They've said they would do it, and they would do it. President Obama did the exact same thing. It's a routine thing to roll back the regulations of your predecessor administration. President Obama, for example, changed his predecessor's regulatory framework on the funding for embryonic stem cell research. He authorized funding for embryonic stem cell research by regulation, whereas his predecessor had forbidden certain kinds of funding for embryonic stem cell research. He rolled back the conscience regulations that HHS put forward for healthcare providers. Rolled those back and replaced them with different regulations. So it's a typical standard practice for a new administration to put in place its own regulations that reflect their own principles. And my understanding of the Romney position, without endorsing it or anything like that, is that this is a matter of significant disagreement with our president. Yes, in the back.
Billy Stoy, senior pre-med. Related to that, would you be worried that if Romney were elected, that we would lose the chance in the Supreme Court to make a decision on this and then not have precedent in that sort of decision?
Yeah, no, that doesn't mean, well, look, let me put on that. As a person that would like this mandate to be altered in a way that allows us, that relieves us of the burdens of it, I would say I would rather the certainty of an administrative change than losing the opportunity for impact litigation. I think that's not, and as a strategic matter, I wouldn't favor that.
Carter,
because let me add to that. The other problem is, regardless of who you vote for, or what you believe, or what your values or priorities are, one of the major questions is, the composition of the Supreme Court looms very large in this election. And so, in some ways, President Obama will certainly have more appointments to make in the next 4 years, almost certainly. And if Governor Romney wins, he will certainly be able to shape the court. So shaping the court is going to be a big factor. Although I will say that on religious liberty, in the ministerial exception case, the result was 9-0 against the administration's position, including by his own Solicitor General, Elena Kagan. And the Department of Justice argued that there was no ministerial exception embedded in the First Amendment religion clauses, which is a very, very unusual jurisprudential position to take, and it was rejected.
Carter, don't you think it'd be not likely to get a big religious liberty decision in terms of precedent, though, because it'd be done under the federal statute, under the Religious Freedom Restoration Act?
If I'm a judge, I'm going to resolve this matter on the most sort of minimalistic grounds that I can't without having to disrupt jurisprudence in a significant way. And the obvious way to dispose of this case is through the Religious Freedom Restoration Act, which is what the court did in Denver. It was a district court judge who had been appointed by President Carter in the 1970s. And it'll be interesting to see what happens in the Religious Committee. Now, I should say, there are some judges who have dismissed these cases because they thought that the case wasn't ripe yet. That is, the plaintiffs didn't demonstrate how they were being harmed imminently. And I think that's, just speaking editorially, I think that's a failure of lawyering. I think that was just not explaining, as John Affleck Graves does in his affidavit, the harms that are imminent as a result of this policy. Yeah?
I'm first year grad student in philosophy. Are there other services that haven't received as much controversy, aside from the contraceptive and sterilization services, that insurance companies are also being required to completely subsidize in the same way?
Yeah, I'm not aware of any controversy surrounding the content of preventative. This was a women's preventative services question that came up in 2010, right? So that's there has been some controversy about pre-existing conditions, and not so much for insurance companies, not involving drugs as much, but with people with pre-existing. And I think, frankly, it's a good thing to limit the capacity for insurance companies or employers to discriminate against people with pre-existing conditions. But that has caused some controversy because I said it would be economical and sustainable. But there's no, maybe I didn't understand your question. Your question is, were there other services that have gotten this kind of attention? Other than the overarching concept of pre-existing conditions, I'm not aware of it. Do you have any that you have in mind?
Well, I was asking if there are were contraceptive and sterilization services singled out as being things that it's essential for people to be given for free, or are there other things?
Yeah, no, so one feature, I think this is in some ways responsive to your comment, that is, some people have noticed how strange it is that contraception, these drugs, the functions, abortifacient, and sterilization, have been singled out as singularly important to cover as preventative services. Not insofar as other ones that have generated controversy, but some people say, why that? What's so significant about those things? Why not certain kinds of cancer drugs or other kind of preventative services that might be efficacious to even a wider population, or deal with more or deal with what some might judge to be more serious kinds of pathologies. So yeah, it's a good question. I mean, if some people have said it seems odd that we're singling these things out for special attention. Now others would defend it by saying, well, these are important. The IOM and others would say these are important because contraception, sterilization, and the informational services related to these things are important for reproductive health, and so that's why we selected those as important. Yes, sir.
I'm sitting here and I'm noticing everybody's asking the questions of that.
I noticed the same thing.
I think these women, especially these young women, some of them ought to be asking the questions.
Yeah, absolutely.
If they're not, I'm going to raise this up. I don't see how you can separate women's reproductive rights from their general health care, their general well-being.
Yeah.
There's just simply no way. And I don't think any employer, and excuse me, but religious included, ought to be sticking their nose into these matters. It's really none of their business. It's up to the individual. Yeah. And look, I know young women, not much older than the women I see here, if they get pregnant again, there's a good chance they will die. Now, no offense to Father Jennings, but do these women, do they have to somehow get his okay if they work at Notre Dame? Do they need his?
Right.
Oh, of course that's ridiculous. That's what I just cannot for the life of me understand how you can separate these issues. And they're just too personal for, frankly, anybody to be sticking their nose, including Father Jennings, to be sticking his nose in.
Right.
I have I'm an older man, sure. I have no dog in this fight. But since I did not see any young women speaking out, I decided I would.
Yeah, thank you for the question. And that's obviously a point of view that has been forcefully represented in this discussion. It's important that you raise it. I'm glad that you did. The argument, I suppose, is as follows, namely, and this gets to, maybe, I don't know if this is directly responsive or not, but there's been a whole debate about coercion and discrimination in this discussion. And there's an argument that I think sounds similar to the important point that you were making, which is to say that it constitutes a kind of discrimination or kind of sticking your nose in somebody else's business for an employer to say, I'm going to pay for certain kinds of health care but not others, right? Now, I guess the first order response by employers, whether we're satisfied by it or not is another matter, is to say, well, I'm not preventing you from pursuing whatever health care you would like to pursue. I'm simply saying that in my judgment, and usually it's a cost-benefit kind of judgment rather than a religious liberty kind of claim, that certain things that we can pay for, certain things we're not going to pay for, and that's something that you that one understands when you get health care. Now, the Affordable Care Act actually changes the complexity of that a little bit because it creates these exchanges whereby people can get out from, and I think the larger part of the problem here is tying insurance to employment more generally. That is, the difficulty is once you have a regime where most people get their health care insurance from their employer, you're going to run into these difficulties because the employer is going to say, well, I have a finite amount of resources, I have to marshal those resources in certain ways, I'm willing to pay for some things, not others. Insurance companies are saying, you know, we are obviously willing to cover certain kinds of risks, but not others because it would be unsustainable for us to do otherwise. And then you have the yet additional concern raised by religious entities saying, look, we have an institution here of a certain kind of character, and we want to run it in an integrated way. And at the very least, we don't want to be put in the position of facilitating activities or access to things that we regard as deeply in conflict with the goods that we affirm. Now, one person could respond and say, well, that's discrimination. I suppose it depends on what the kind of ex-ante entitlement is. If you believe that your employer is to give you any form of health care that you want, and that's the ex-ante entitlement, then it would be a kind of discrimination or a kind of injustice for them not to do it. If you, on the other hand, think that there's a sort of a process by which employers and employees and insurance companies work out what they are and aren't going to cover based on religious liberty, the character of the institutions they have, the amount of resources that they have, then that, I think, becomes more complicated. And I think the position of these religious institutions would be, look, we're not preventing anyone from getting access to contraception, and according to Planned Parenthood, generic contraception costs $9 a month. You can get it, this is the statement from Planned Parenthood's website, from different nationwide things. You can get $24 a month if you want a more expensive one. If you want to go brand name, it can cost between $60 and $90 a month. And there's payment assistance through Planned Parenthood, through Title X, through all kinds of other mechanisms. And I would say that as a political matter, in a diverse polity that respects religious liberty and religious integrity, we could find another way to give access, if we want to give access to these kinds of things, without conscripting those institutions into doing so. You could subsidize it directly. The government could write a check, a tax credit for every single person, for every penny that they spend on these services. Or you could direct these Title X clinics to simply give it out for free. But what's happening in this case is the compulsion, in my judgment, the coercion of religious institutions to provide these things without, and you asked a question about health concerns. Now, my understanding is that the Notre Dame and other similarly situated institutions, if there is a pathology that requires a drug that can also function as a contraceptive, that is going to be covered by the insurance plan. That is going to be covered by the insurance plan. Which is to say, if a person's life is in danger from pregnancy, or they have a condition like endometriosis, which can be ameliorated by the off-label use of these drugs, then that's going to be covered. So it's a kind of accommodation situation. I mean, I wouldn't agree with you, I don't think, that there's an absolute entitlement to all forms of health care from an employer without the employer being involved at all in the process of deciding what they can afford, or more importantly, what offends their institutional character. So, yes, sir.
Williams, sociology. I like your alternative mechanisms. I suspect the Obama administration would like them if Congress would go along. But I don't really see how that's morally superior. You're basically shifting the burden from institutions who oppose birth control to taxpayers, some of whom oppose birth control.
Yeah, that's an excellent question. Is there a difference? I don't mean to cut you off. Is there more to your? Yeah,
there is, but go ahead.
Okay, let me just briefly respond to that. I think that's a great question. I think that there is a difference, and again, with respect to the direct compulsion of an institution of a certain kind of character to engage in a pattern of activity that finds anathema to it, the goods that it affirms, and asking a citizen more generally to pay taxes into a general fund that is allocated according to the judgments of the political branches, the accountable political branches. Now the question of complicity with respect to taxpayers is a complicated question, but I think it's a much harder question than when the government says, Notre Dame, you have to facilitate access to these drugs and services.
Okay. The broader question, Ed, you said it's an unprecedented violation of religious liberty, but government places all sorts of restrictions on religious liberty.
Right.
Polygamy is illegal.
Exactly.
Bigamy is illegal.
point.
Christian Scientists and Jehovah's Witnesses oppose blood transfusions.
Muslims
oppose mixed gender medical facilities.
100%.
As far as I know,
Yes, sir.
neither of those religious groups is filing lawsuits, and if they did
Well,
file
polygamy
lawsuits,
ones are, yeah. In the marriage context, there are some interesting.
Okay. But in any event,
No,
religious
yeah.
liberty is not unlimited. Now,
I agree with that.
We can argue, okay, where's the dividing line here?
Yep.
I guess you have an idea, where do you draw the dividing line?
Yeah, that's a great question, and it was similar to what was asked by the engineering student over here, namely, where's the line? Like you can't. If I want to harm somebody, or if I want to do something that's obviously against a neutral, general applicable law, I think that the Religious Freedom Restoration Act strikes a nice balance, actually, because what it says, it does say religious liberty is not an absolute good. It has to give way in the name of other goods in some certain circumstances. I think the way the Religious Freedom Restoration Act balances those concerns is by saying it has to be a compelling interest, a recognizably compelling interest, which this may be in this case. I think we could argue about that, but it may be. But secondly, the means chosen has to be the least intrusive means available of impinging upon the religious liberty interests of the affected group. So the court will decide if the means selected, in the face of a compelling interest that's been legitimately asserted, if the means selected is the least intrusive means. If the least intrusive means compels you to do something against your religious views, that's the result. That's
the administration have the ability to unilaterally implement any of those less intrusive means, or would it require?
No. In terms of the structuring of the exchanges under the Affordable Care Act, I think they could unilaterally do that. They could unilaterally. I mean, they have the Health and Human Services and the Centers for Medicaid and Medicare Services has a great deal of authority to authorize under Title X more or less subsidies. So I think there are things they could unilaterally do without involving Congress that would be less intrusive. Yes, ma'am.
Christy Pellegrini, civil and environmental engineer in earth sciences. My question, well, basically from you talking, you say a lot of this hinges on Title X. However, there's been a lot of push, mostly from conservative parties, to defund Title X and to no longer fund services like Planned Parenthood.
Mm-hmm.
So if all of this hinges on Title X being there, what happens once Title X is not there?
Yeah.
Or if it becomes defunded?
Right. Now, that's a good question. So there are a whole array of different proposals that have been offered with respect to, I've not seen a proposal ever suggested that came to the floor, certainly that came to the floor, to defund support for contraception and sterilization. I have seen a number of efforts to try to defund those organizations that provide abortions. Indiana did that. And our Medicaid money, our $4 billion in Medicaid funds, which are meant to provide health care for the poor, was threatened and is being threatened. We're actually having to sue the government to get our $4 billion in Medicaid money because until we restore funding to those healthcare entities that provide abortion. So Title X, as an entity, I don't think is in danger of going away, and I've never seen any support for the proposition that contraception, access to contraception should be the funding for contraception should be restricted. The heat in that debate has been focused on the question of abortions and abortifacients, and I think you can break that out analytically from what we're talking about here. Stephen Smith.
A great talk as always. I wonder about the end game of what they were doing. I mean, I think you're absolutely right. There are alternatives, ways of easily have workarounds for Catholic institutions, other institutions. They could have taken to broaden access.
Yeah.
And on the access point, I don't know of anybody in this country who has problems with access to contraception. If you want it, you can get it from Title X through other means. So this was not about access, it was about something else. And so I wonder what the something else is. It seems like they went out of their way to force Catholic institutions into this position, to require them to provide these services. Now, why would they do that? It seems to be maybe they want Catholic hospitals to go out of business, in which case private institutions and maybe government can take those over. Maybe they just want to stick it to the Catholics and force Catholics to change doctrines that they don't think is right. What do you think the end game is?
Well, it's a really hard question, and one would be speculating. I mean, I think there is, some have suggested that the idea is that by imposing these rules, you make it harder for certain kinds of mediating institutions to participate anymore in the provision of social services, which then leaves in place only governmental institutions. Now, if you put this together with a series of other events on the part of the administration, I think there's a worrisome picture that kind of comes into focus a little bit. Namely, the event that I'm thinking of, so there's a really very highly regarded program for the victims of human and sexual trafficking that the Migrant and Relief Services of the U.S. Conference of Catholic Bishops has been running since 2006. It's a very, very good program. They're extremely helpful with these victims. They had a grant from the federal government, multi-million-dollar grant to pursue this. They had great results. And then in 2011, it came time to renew the grant. And so they applied to the Department of Health and Human Services for renewal of the grant. The career bureaucrats on the HHS panel, pursuant to their criteria, rated the program along with 5 other competitors and rated the USCCB Migrant Refugee Services #2 in terms of excellence, thus qualifying for renewal of their $6 million grant. Well, a month before that, they had changed the rule, the criteria for grant making in this particular area, that those entities that care for victims of sexual and human trafficking that don't provide for or refer for abortions get downgraded in their rating system. Even with that, which is already, in my judgment, is going to have an impact, a disparate impact on religious social service agencies, obviously, right? But even with that restriction, the Migrant and Relief Services got #2 out of 5, got offered renewal. And then a political appointee from the Department of Health and Human Services came to there and revoked that judgment and said that you were not going to be renewed for funding. And they awarded funding to lower scoring applicants who do provide abortion and referrals for abortion. And so, and there was a whistleblower among the panelists, the career HHS employees who did the rating system. This is outrageous. Why are we doing this? So, that combined with that instance, combined with this instance, there definitely seems to be a kind of systematic effort to exclude, and I don't know about on religious grounds, certainly has a disparate impact on certain kinds of Catholic providers, exclude from serving people in the healthcare context, in victims of sexual human trafficking, from government resources to provide care for these folks, unless they subscribe to the same kind of normative set of principles, especially involving abortion. So that to me is a very worrisome sign and frankly, the idea that Indiana would have its Medicaid money taken away from it. That's $4 billion money just to go to the poorest of the poor and provide them with health care. Because our state legislature, after a process of examining each locality of where there was a Planned Parenthood entity or an entity that provides abortion that was receiving state taxpayer funding, they did a survey to find out how far away geographically is one that doesn't provide abortion. So if we take away this money, will there be people who only get their health care from these entities, and therefore they'll be adversely affected? The governor's office did a study and showed that within 1 mile of every single one that was going to lose its funding, there was one that had a good reputation that would receive funding. And the response was, and so there was no concern about adverse impact on the poor with respect to health services more generally, aside from the question of abortion. So the state legislation took away the money for abortion, not just singling out Planned Parenthood. And then the government's response was, you give that money back, or we're not going to give you the block grants to take care of poor people who need health care. And that strikes me. So you take that example, you take this example, you take the example of the Migrant and Refugee Services, and a worrisome picture starts to come into focus. There's something, I don't know if it's antipathy, I don't know what it is exactly. I'm not going to speculate about what it is, but it is relevant to the question of the First Amendment. If you're singling out an entity, an organization because of its religious identity, that matters in terms of deciding whether or not the First Amendment forbids it. Debbie?
There are other medicines that people have tried to try and get covered, for example, contraceptive medicine. It's one of the few medicines that there's no alternative. You're dead, period. We can't get any traction on that. There's no help with co-pays. In fact, this administration has taxed the products that help deliver these. Now, under this mandate, there's an additional tax on medical, which is what helps deliver the insulin. And then I have a comment on this. My daughter was raised to be smarter.
Debbie, can I just make, I don't think, because of volume, I'm not sure if I heard your point.
And I'm shy, so I'm having a hard time.
No, her point was that, and this in some ways relates to the question that philosophy graduate student asked as well, namely, what about other drugs? Why single out these kinds of drugs for waiving cost sharing? And Debbie's point was insulin, which is a life-saving intervention, is not subject to this kind of a waiver. And there are people who will literally die without having insulin, and yet they're made not only to pay for it with cost-sharing mechanisms, but also she made the point that there are taxes that have been imposed on the delivery systems, which make it even more expensive. So that was the first point. So go ahead, what was your second point?
And the other comment was my daughter is current college graduate, and she's smart enough to know. I just think it's very misogynist of humanity, especially this administration, to think that these young women are not smart enough to know where to get $9 pills, when right now it costs my daughter more to drive to work. She's a nurse, obviously doesn't lie. There's the price of gas and for the pack pills. So I really think these young ladies are a lot smarter than us.
So,
Okay, let's get one.
Yeah, I just want to repeat, in case you didn't hear it, I'm reporting what the second comment was, namely, she raises what sounded like a kind of feminist concern about what she takes to be a paternalistic impulse that's behind this, and therefore would criticize it on a feminist ground. So one more question. One more question, John O'Callaghan.
Just one more instance, and I don't know, in terms of the parallel with the concern of Notre Dame about the mandate, but on this question of other sorts of things, I believe prenatal diagnosis, which of course doesn't violate any Catholic teaching, prenatal diagnosis is in the healthcare bill under the aegis of preventative services. But that raises a sort of different sort of question about cooperation and so on, because as I say, it's not like contraception where it violates some Catholic teaching.
Right.
There's nothing inherently wrong with prenatal diagnosis in the church. And yet, it's in the bill as preventative service.
Right.
But the point about a prenatal diagnosis is all it does is diagnose a disability in an already living child.
Right.
And so the question is, what would preventative in the bill mean?
Yeah.
If that's a preventative service.
Well, I think it's clear what it means, and that is to say, prenatal diagnosis is a preventative service. If the intervention, you can make an intervention that will correct the abnormality in the child in utero, or more likely, have an abortion, which is deemed. Now, let me just.
Some of the things being tested
Yeah, go ahead.
aren't curable.
Okay, so that would clearly fall into the second category, and as we all know, in my judgment, that one would pursue, and unless you have a pathology that requires either pregnancy, you'll die because of a pregnancy, or because you have some other condition that is off-label prescription of these drugs would be useful to ameliorate. That's a more, I think, conventional definition of preventative. So if preventative expands to include questions about preferences in a